Good morning. You are listening to CKLN 88.1, and this is show number 32 in the radio series on mind control. Today we're going to hear a presentation by Professor Alan Scheflin, given at the recent International Society for Study of Dissociation and International Society for Traumatic Stress Studies conferences in a joint session in Montreal just last Sunday on November 9th, 1997. This talk is entitled Risk Management in Dissociative Disorder and Trauma Therapy, and is very timely in the wake of some very disturbing legal developments against psychotherapy recently. There was a $10.6 million lawsuit settled out of court in Chicago for a therapist who treated dissociative identity disorder or multiple personality disorder. Also, more recently, the U.S. government has brought criminal charges against Judith Peterson, a Texas psychologist who treats dissociative clients. The charges allege that Dr. Peterson has intentionally created and diagnosed DID and intentionally implanted false memories in her patients in order to keep them in hospital longer, thereby providing fraudulent therapy for traumas that did not occur. Also, Dr. Peterson is being charged with mail fraud, as she had mailed some of her bills to her clients for this allegedly fraudulent therapy. The federal government has only interviewed her patients that have retracted and their attorneys, and have not interviewed Dr. Peterson or other positive witnesses. The alleged victims of fraud filed multiple complaints with the Texas Board of Psychology, which has dismissed 11 of the complaints against Dr. Peterson. In addition, numerous complaints have been filed against her with the Texas Department of Mental Health and Mental Retardation and the Texas Department of Health. And through their investigation, she is found to be without fault in each complaint. With these government indictments, Dr. Peterson will be forced to mount an expensive legal defense against these criminal charges. This is a precedent-setting move for the U.S. government, as allegations of these type in the past have been dealt in civil courts as malpractice or negligence complaints. If the U.S. government is successful in their prosecution, this will in effect criminalize psychotherapy. So for today's show, we're going to hear this very timely talk by Alan Scheflin, who is a professor of law at Santa Clara University in California and was one of the original writers and researchers of CIA and U.S. Army mind control experimentation in his book, The Mind Manipulators. He has recently co-written an encyclopedic reference called Memory, Trauma Treatment, and the Law, just published this past month. This book provides guidelines for therapists dealing with MPD, DID, and trauma survivors in this atmosphere of lawsuits against them, which is encouraged and aided by such groups as the FMSF. And now, Professor Alan Scheflin with an introduction by Marlene Steinberg at the recent ISSD conference. You're listening to the International Connection on CKLN 88.1.
Today's joint sessions focus on recent advances in both treatment and research of trauma survivors. While research on PTSD and the dissociative disorders has progressed considerably over the last decade, we have worked relatively independently of one another. We here also celebrate the ISSD's conference theme, The Brink of a New Era, which also applies to today's joint sessions. Since we all treat trauma survivors, be they veterans or adult victims of abuse, it is crucial that we work together to foster clinical advances. On behalf of ISSD and ISTSS, I hope that these joint sessions will both help you in the treatment of trauma survivors and lead to collaborative projects among members of the two societies. So I welcome you. Now I would like to introduce our keynote speaker, Professor Alan Scheflin. This is indeed an honor because I can think of nobody whose work integrates as many crucial areas in mental health as Alan Scheflin. Alan is Professor of Law at Santa Clara University Law School. His expertise covers clinical and experimental research on hypnosis, memory, and trauma treatment, as well as their import in the law. He is the forensic editor of the Journal of the American Society of Clinical Hypnosis and has co-authored numerous books including The Mind Manipulators, Trance on Trial, Clinical Hypnosis and Memory. His professional awards are numerous and include the American Psychiatric Association's Manfred Guttmacher Award in 1991. In addition, Professor Scheflin has been recognized in federal court as an expert on mind and behavior control, and in state court as an expert on suggestibility, memory, and hypnosis. Professor Scheflin's most recent book, co-authored with Drs. Brown and Hammond, Memory, Trauma Treatment, and the Law, has just been published by Norton last month. And Professor Scheflin will be available at 4:45 for a book signing. Given the recent controversy about traumatic memory, this book is essential reading for all of us involved in treating trauma survivors. We are fortunate to have Alan here today and to share with us his thoughts on risk management in dissociative disorder and trauma therapy. Please help me welcome Professor Alan Scheflin.
Thank you, Marlene, and good afternoon. It is indeed an honor to be here and to talk with you and both of your important organizations on a topic of grave concern, I think, to all of us. I feel especially privileged because I'm very much aware of the great humanitarian work you do with people whose lives have been shattered by the worst of human atrocities and natural disasters. You spend your days healing and helping and caring and curing, and the attacks on you are unwarranted and unfair, but in need of defense. And I vow to you that I will continue to assist and advise and to help and protect you in any way that I can. And in that spirit, let me talk to you about risk management and what it means in the current climate. What a difference a decade makes. In the second of a three-part series in the Wall Street Journal in October 1986, the journal reported a study conducted by three researchers who had analyzed 475 studies and concluded, quote, "The results show unequivocally that psychotherapy is effective," unquote. 1 month later, the American Psychological Association Monitor reported on how litigophobia, which was defined as the unreasonable fear of being sued, was having a direct negative impact on patient care, disrupting not only therapists' lives, but the lives of patients and families as well. In a related article in that same issue, the statistics demonstrated that psychologists were rarely sued, especially concerning talking cures. Indeed, Cohn, in the most comprehensive review of mental health malpractice at that time, wrote, quote, "Mental health professionals have remained relatively unscathed by claims of malpractice. Suits brought against psychologists, psychiatrists, and others have been relatively few in number, and relatively low dollar amounts have been paid in damages. It has been observed that the average American psychiatrist is sued once for every 50 to 100 years of practice, whereas the average neurosurgeon can expect to be sued for every 2 years of practice." Thus, a decade ago, the message was, be happy, don't fear lawsuits, and rest assured that what you're doing was going to be effective. To a professional working today in the mental health field with trauma and dissociative patients, it must seem as if the world has gone mad. First, managed care has invaded the privacy and the autonomy of the therapist-patient relationship. As law professor Walter Wadlington has observed, the Byzantine system through which healthcare is delivered in the United States has seen major changes over the past 2 decades. a scheme in which physicians exercise principal control over decisions about the use of facilities, choice of treatment, and determining what information should be disseminated to patients, has given way to a system in which competition and cost containment have become dividing forces and driving forces. Insurers and other large business entities exert great impact over treatment choices and hospitalization, as well as selection of providers. Second, right in the middle of that golden decade, 1986, in October of 30th, 1986, in fact, the Washington Supreme Court, in a case called Tyson versus Tyson, decided at the appellate level the first repressed memory case. In its opinion, the court rejected the idea of repressed memory and refused to extend the statute of limitations to victims of childhood sexual abuse whose memories had been recovered later in their lives. Although that ruling was overthrown by legislation, and now the law is quite different in the state of Washington, it began a cascade of cases through the legal system and an avalanche of bills through the halls of legislators. And of course, the recovered memory debate has been the most divisive debate in therapy, certainly for this half of a century. And it's, I suppose, good timing, but an unfortunate thing to report. You must have all seen the story about the $10.6 million settlement in Chicago. Other cases are now pending. Indeed, in the newspaper today, there were more anti-therapy, anti-repressed memory stories. Also, third, we have the shocking announcement from Texas that the government has now decided to bring criminal charges against therapists who are working in the MPD and dissociative fields. These are grand jury charges, but they will require a rather expensive, indeed a hugely expensive defense, and it's my hope that the entire profession will rise to the occasion and resist these egregious charges that are brought against individual therapists, but which really try to indict the field of psychotherapy itself. Fourth, a development that is less well known but even more dangerous. The courts are now flirting with the idea of allowing third-party liability suits to be brought against therapists. That means that if you believe your patients, their families will sue you, and if you don't believe your patients will sue you. And so you're caught in a trap for which there is no escape, and the notion of conflict of interest, which all professions must obey, is simply thrown out the window. I'll talk more about that later. In this climate, what can conscientious therapists do? Let me quote to you from an article by Ray London in the International Journal of Clinical and Experimental Hypnosis, January this year. The best risk management program is found when a responsible clinician uses sound professional judgment, establishes a positive therapeutic alliance, obtains necessary positive consultations, and documents what is done on a regular basis. That's good advice. But the rest of what he has to say in that paragraph, which I'll quote, is no longer applicable. He said, quote, "We should not become so fearful of our legal vulnerabilities that we cease to use our sound judgment and training, nor should we allow other professions or the uninformed to determine the standard of care." Well, unfortunately, other professions and the uninformed have now stepped in to determine the standard of care. The standard of care, being a legal standard, is informed by good medical practice. But by being a legal standard, it can be manipulated by lawyers and propagandists and other people, and that is what has happened. And therefore, it is necessary for the mental health profession to wrest back control of the standard of care from the avaricious lawyers that are in the process of changing it. With this in mind, I present to you as probably the most important kind of risk management a rather grisly image that I'd like you to keep in your minds when you treat patients. I want you to see with double vision that every patient before you has sitting next to him or her a lawyer with a yellow pad scribbling furiously at everything that you say. Although you might not actually see the lawyer, that lawyer is there. And therefore, good risk management keeps at least one eye on the legal consequences of what it is you're doing. I don't like to be the bearer of that news, and I don't think that this development is a fortunate one for either therapist or patient. But I would be remiss in my duties if I didn't warn you that as far as lawyers are concerned, they will be in that room with you. If they're not present at that moment, they will have access to your records and to your notes and to your thoughts. And it is better to think of them as being there and be cautious than to have to deal with them later in real life. All right. All of this has nothing to do with science. In fact, the science is on the side of the therapists. In the midst of these horrible stories that we have seen in the paper today in Montreal, in the New York Times, in the London Times, about the Texas cases and the Chicago cases and so on, nobody has paid attention to an article in the London Times reporting on the 37th study demonstrating the validity of repressed memories. That 37th study, which the media buries in the back pages, and indeed most newspapers don't cover it all, should be put into context. Because on the one side, there are 37 studies showing repressed memory as a real phenomenon. On the other side, there are no studies showing repressed memory does not exist. And the argument that is sweeping across the country through the media and through courts that repressed memory does not exist is scientifically unsound. It is the phrenology of the 20th century. But in courts of law, it is persuasion and not proof that prevails. And therefore, it is not going to be enough to have the science on your side right now. Ultimately, that may be true, but right now it is not. So let's review some of the arguments that are used in the false memory cases and recovered memory cases, and then let's talk about how to deal with them preventively and how to deal with them when the cases actually arise. The essence of the false memory argument, the root of all of the cases, is the idea that the therapy relationship is a relationship of undue influence, and that the patient has been talked into a set of beliefs that are untrue. In this regard, the image of the therapy room is identical to the image of the police interrogation room, or to indoctrination into a highly structured religious cult. That the same kinds of brainwashing procedures that filtered into police interrogation tactics are in use by therapists. And therefore, what people report in therapy is really what they have been programmed to say by therapists, some of whom are just naive, but most of whom are malevolent and are trying to make extra money by filling beds or filling their schedules with insurance money. This is the essence of the false memory argument. Now, in particular, it's built upon a couple of sub-arguments. First, that repressed memories do not exist, and therefore any memory that comes out first in therapy must be a memory that had been implanted in therapy. So we have now a 100% litmus test for historical accuracy. If a memory comes out in therapy, it is automatically false. Now, the people who say this also say and write that memory is malleable, and that memory can never be trusted, and that no memory carries with it an indicia of its truth or falsity. However, in the same breath, they also argue that if a memory comes out in therapy for the first time, that memory must necessarily be false. In response, there are, as I said, 37 studies against no studies showing that repressed memory, or what is more appropriately called traumatic amnesia, does exist. Most of the good lawyers on the false memory side have recognized that they can't win the argument any longer, that repressed memories do not exist, and they've backed away from that position. The studies are too overwhelming, and the false memory arguments in support of the absence of repressed memory are now too fallacious. And so they move to another series of arguments. The most predominant one is that MPD, or now DID, is always iatrogenic. That this is not a natural condition to be found in nature. It's only found in the therapy room. And that therapists create MPD in order to treat MPD. And they treat MPD in order to get money to treat MPD. And so again, the economic argument is at the base. To buttress the position that MPD is always iatrogenic, the argument goes that the DSM-4, which acknowledges the existence of DID and acts as the standard of care for therapists, is in fact a social convention created by a bunch of good fellows who flip-flop on major issues such as antisocial personality, sociopaths, and homosexuality. And the history of the DSM shows, according to the argument, that this is simply an agreed-upon self-energizing, self-interested document that generally bears no correlation to what we find in nature. Well, there is, of course, some truth to the idea that the DSM-4 is a social convention, but I want to remind you of another social convention. It's called law. And you can no longer decide to not obey the speeding laws than you can to not obey the MPD or DID section of the DSM-4. Because surely anybody who says, I'm going to go through the DSM-4 and pick and choose what I like, and not diagnose any of the conditions that I don't like, is violating the applicable standard of care. And since you can't, in the legal system, which is a social convention, decide which laws you choose to obey and which laws you choose not to obey, then as long as the DSM is in force, it is the law, and it must be obeyed. For those people who want to argue against MPD, they have every right to do so, and they should marshal every argument they can. But right now they've lost. And in the DSM-5 or the DSM-12 or the DSM-100, maybe they'll win. But until they win, it is malpractice for them to tell people to ignore any part of the DSM-4. And it is malpractice for you, of course, to ignore it as well. In addition, and I don't want to turn it into a scientific talk because there isn't time to do that. I wanted to focus more on risk management and the arguments that are applicable. The idea that all MPD is iatrogenic is false as demonstrated in the literature. I think the most cogent and simple argument is the one in the British Journal of Psychiatry, November 1988, by Thomas Fahey, who after a review of the literature shows that while you can get people to simulate being MPD, you cannot get people to simulate the disorder. In the same way, I can get people to act as if they're drunk, but I can't get them to measure intoxication on a meter. And therefore, and over a long period of time, it'll be very difficult for somebody to simulate being grossly intoxicated. In the same way, it would be very difficult, if not impossible, to simulate over a long period of time having the actual MPD disorder. And consequently, there are arguments that can handle the notion that MPD is always iatrogenic. More significantly and with more difficulty is the argument that it's easy to implant false memories. This is an argument, well, of course it must be true. Read any newspaper now about the science in this area. It is easy to implant false beliefs, such as the idea that repressed memory does not exist. But the science does not show what the lawyers claim in court. The science shows that it is very difficult to implant, quote, false memories, unquote, about emotional events for which there is no prior basis in fact. And again, I won't go through the literature. I've done that in the memory trauma treatment in the law book, where you have all of the literature brought together in one place. But it is easy, of course, to talk people into some things, but it is very difficult to talk them into horrendous things and have them believe it. It is also untrue that these things are memories. These things, if at worst, are beliefs, but they are not memories. And while we're on that point, I've always been amused at the idea of recovered memories. What memory is not recovered? By definition, a memory means that you have recovered it. And so the whole notion of recovered memories is another way of fooling the public into a set of false beliefs. The more serious problem, though, with this area is that people are willing to believe that there are specialized techniques, in particular hypnosis, that can facilitate altering the way people think and act. And the Hollywood version of hypnosis is always fresh in their minds, because that's the only version that people generally have in their minds. And so there has been an attack on hypnosis. But realistically, the attack on repressed memories was an attack on hypnosis, and the failure of the mental health and medical communities to respond to that attack is what has led to the current repressed memory controversy. If we go back in history, we find that the first case in the United States to allow hypnotically refreshed recollection into a court of law was 1968. From 1968 to 1978, every court in the United States recognized the right of people who had been hypnotized to testify. Beginning in 1978, a court said, well, maybe there are some dangers with using hypnosis. And in 1980, the Minnesota Supreme Court in Minnesota versus Mack ruled that hypnosis is always dangerous, always contaminates memory, always causes confabulation, results in undue suggestion, makes the hypnotized subject more self-confident, and indeed so self-confident that he or she becomes entirely resistant to cross-examination. And therefore, anybody who has been hypnotized is automatically disqualified from testifying. The exception was made for people who had previously recorded a hypnotic a statement of their factual memory. And so if a person was a witness or a victim to a crime and gave a statement to the police before hypnosis, that person was permitted to get on the stand and tell the story that was told before the hypnosis. Anything remembered during or after the hypnosis, or any identification after the hypnosis of a possible suspect, was inadmissible. Many of us argued that these rules were unfair. They misunderstood the nature of hypnosis, and they disenfranchised patients who had the right to get mental health and also exercise their legal rights. And we urged the medical and mental health communities to file briefs in court to resist these egregious rulings. But our voice was unheard. It then became clear there was a secondary threat. And the secondary threat was for therapists who use hypnosis competently and wisely, to have thereby disenfranchised your patients from testifying in a court of law could be considered malpractice. And therefore the patient could turn on you and say, yes, I know you used hypnosis therapeutically for me, but now I can't sue the person who I can now show was the person who abused me. I'll give you a case that makes this point clear. This is a true case from New York. A therapist called me and asked if the district attorney could talk with me. I said yes. The district attorney called me and said, we have a 9-year-old girl. When she was about 5, she went to her mother and said in 5-year-old language, "Daddy is molesting me." The mother had a psychotic breakdown and was institutionalized and remained institutionalized. Who do you think got custody of the child? It's now 4 or 5 years later. The child absolutely refuses to talk about it. The child learns what happens when you talk about these things. There is medical evidence of abuse. So that this is not a false memory. This is not something that cannot be corroborated. But of course, the medical testimony will tell you there is abuse. It doesn't tell you who is doing the abuse. A therapist working with the child for over a year using non-suggestive techniques was unable to get any information from the child. Hypnosis was used, the child was relaxed, the child told the whole story. And the story again is confirmed by the medical evidence. Because the hypnosis is used, the child is now forever disqualified. Her testimony is inadmissible in court, and if she should seek to sue her father, she would be disqualified as a witness in that case also. I don't think that rule is fair, and I have argued against it and written against it. But then I wrote Trance on Trial to alert you to the fact that that child could then sue her therapist for using hypnosis. And if you have not given the patient an informed consent form that explains that under the law, if we use hypnosis and you discover any information which can be corroborated that could lead you to have a legitimate lawsuit against the third party, you will be disqualified from doing so because the hypnosis was used. And if you are using hypnosis or indeed working with memory at all, you also need another informed consent form. And it is now good clinical practice to let the patient know what the literature in fact does demonstrate about memory. Memory is malleable and it is not historically accurate necessarily. Nobody has ever asked the false memory people how they remember their names, of course, or how they know what home to go to at the end of the day. So a certain part of memory must work. But there is no guarantee that any particular memory is accurate. No matter how much emotion is invested in a memory, no matter how much detail is in a memory, no matter how much impact the recovery of that memory has on an individual, it may still be inaccurate. That's true out of hypnosis, and it's true in hypnosis. And patients ought to know it. Because most of what has happened with there are two major kinds of false memory legal case. One is where the patient sues the therapist saying, you essentially talked me into believing that I was a certain kind of person, MPD, with satanic abuse and mind control programming and so forth, and I was really none of those. The other kind of case is where the patient goes out into the world, confronts the family, has a break with the family, accuses the family of incest or sexual abuse, and the family is now disrupted. It's the second kind of case that I'm talking about, where there is an outside the therapy room encounter. Good risk management suggests that you keep the therapy in the therapy room, and that any activity that the patient wants to take in the outside world is the patient's decision, not yours. You should not urge confrontation with outside people. You should make it clear that no charges or any actions should be brought against a third party without independent corroboration and probably without the advice of a lawyer. That the therapist works with material in the therapy room, whether it is historically accurate or not. Once that material goes outside of the therapy room, it should not be your responsibility. But it is your responsibility to let the patient know, first, that it isn't your responsibility what the patient does outside, and secondly, that the patient, before doing anything outside, should be aware of the fallibility of memory and should not act hastily on the fact that a memory has been recovered. All right, I've got to move on. Let's go talk about satanic cults and then mind control programming. The American public is not interested in hearing about the existence of satanic cults and mind control programming. Do satanic cults exist? Of course. There is no doubt about that, except in the minds of some people. But those people do not include the FBI. Because if one reads Ken Lanning's report, which is not an FBI report but a personal report, the FBI certainly recognizes the existence of satanic cults. There are many books reporting on Satanism and satanic cults. The American Family Foundation, which is the foremost organization monitoring cult activity, has issued at least 2 reports on the existence of Satanism and found a variety of different kind of satanic practices that occur. The newspapers are filled with stories about satanic rituals and satanic cults and so forth. The fact of the reality of satanic cults does not mean that juries are necessarily going to want to hear it. It's not that they disbelieve it, it's that they choose not to hear it. And so in working with people who report satanic abuse, you have to be very careful. And here is where good note-taking is extremely important. There are 2 schools of thought about note-taking. One is the less I say, the less they can pin on me. That is not the preferential view. Taking notes, you have been taught, is a way of doing good therapy. I tell you now it serves another purpose. It serves as a legal defense. For you to accurately report in full detail what happens in therapy sessions may be the best defense you have. Because if the ideas of Satanism come from the patient and not from you, your note should reflect that. And your note should reflect that the patient kept going back to the issue of Satanism and kept insisting that the issue be talked about. And your note should demonstrate that this is not something that you have created in the mind of patient, but rather something that has been generated by the patient, and the patient's demeanor has indicated that he or she is not likely to get better or to hear other kinds of discussion unless that subject is covered. There is nothing that prohibits you from talking about these things, but make sure you document that this is not something that you are implanting. And the kinds of things that the patient is reporting should be reported in your notes as the patient said this, the patient said that. And I responded, is there anything else you want to say? Do you have anything else to tell me? Or other non-suggestive forms of open-ended questions so that you cannot be accused of leading or using undue suggestion. With mind control programming, the issue is a little more difficult because while we can show the physical reality of Satanism, and by the way, let me make another comment about Satanism. The FBI report and Gail Goodman's independent research have demonstrated that there is no empirical proof of multi-generational international conspiracies of satanic organizations. And we have to assume that that's a fact. But that fact doesn't mean that there isn't international networks of trafficking in children for pedophiles. And indeed, in another one of those little stories buried in a back page, there was just an enormous arrest in Italy of a pedophile ring that was buying Chinese children and shipping them around the world. Those stories are, of course, ignored in part by the media. But what we are now learning is the kind of things that we have heard of as ritual abuse in a satanic context may actually be a form of international ritual abuse in a pedophile context. And the FBI has acknowledged the existence of international rings in trafficking in children. And so we're only starting to learn about these things. It is not your job to be a detective, but it is your job to be a good chronicler of the stories your patient tells you, and to have your notes reflect the fact that you are not creating, implanting, suggesting, or influencing these stories. With mind control programming, the problem becomes even more difficult. Is there mind control programming? Of course. Indeed, many of the false memory people wrote some of the best works on mind control programming, and did it in the context of religious cults. I myself wrote the definitive version of the Central Intelligence Agency and U.S. Army's mind control programs that were secret programs that extended over a period of 25 to 30 years. I read somewhere between 12 and 20,000 pages of previously classified secret, top secret, and eyes-only documents to put that book together, the books of the Mind Manipulators, currently out of print. We can document that thousands of people, including mental patients, juveniles, and others, were unwitting victims in CIA mind control efforts. But these programs are largely unknown to the public. The idea of mind control programming has such an aura of science fiction about it that people do not like to hear it. And therefore, in your note-taking, you must again be very careful to make sure that you don't indicate any influence by you on the patient in reporting these kinds of events. Also, with satanic cults, with memories, with mind control programming, it is easy to lose sight of the ball. The ball is stabilizing the patient, making the patient able to function in the outside world. All of these other things are distractions at worst, or things that need to be discussed at best to be overcome in order to get to the real business at hand. A lot of the problem that has generated the lawsuits is that these areas have been found to be so intriguing that the actual treatment goals have been lost sight of, and instead the idea of investigating multinational trafficking in mind control programming and so forth had become the centerpiece of the therapy. And so as seductive as these things are, be careful that you don't lose sight of the treatment goals. And your notes are the best place for that information to be transcribed and to be available later. While we're talking about information and knowledge, there is no substitute for knowing the literature. And I think what has happened to therapists, and I've said this for many years, but I'll continue to say it, is that you were blindsided by a literature you never heard of, and which you are now expected to master. And your failure to know about that literature has been the basis of many, if not all, of these lawsuits. I personally have yet to see a lawsuit in this area, and I've seen a lot of them, where the literature on brainwashing, mind control, undue influence, police interrogation practices, and social influence and suggestibility have not been thrown at therapists. Generally, the only aspect of those literatures that you're exposed to are interviewing and techniques and the difference between closed and open questioning. But there is a rich and incredibly fascinating literature that you now must be aware of, not only on memory and the available ways in which memory may or may not be influenced, but on suggestion and suggestibility, on police interrogation practices, and on mind control and brainwashing. There was a case in New England where a therapist was being sued and the deposition was a month away. The therapist called in desperation asking for help. And I said, here's what you need to do, and gave a reading list to the therapist and names of people in her area who could train her in these literatures. The deposition occurred, and about an hour or two into the deposition, the lawyers took a break and went into the men's room. And in the men's room, they said, we're not going to get anywhere. She knows too much. She's too familiar with the literature. Her husband was in the men's room, and the lawyers didn't know it. And her husband was able to report this back to her. We had trained her in that month to be available for the literature, and they could not touch her on deposition. You now have to know that literature as well. And just as I wrote Trance on Trial to protect you from the lawsuits by the patients claiming malpractice, Dan Brown, Corey Hammond, and I wrote Memory, Trauma, Treatment, and the Law to bring together in one place all of the available literature on memory, brainwashing, police interrogation, and so forth, so you can at least see what that literature looks like. And the more familiar you become with it, the more you will be doing your own risk management without realizing it. Because mistakes you would otherwise have made, you will no longer make. For example, Many of the people who deal in the area of mind control programming were in the early days lured into the notion that there are certain kinds of programs that exist, certain kinds of programming, certain people who are doing the programming, and so forth. Those of us who work in the area of mind control and brainwashing know that almost everything we hear is wrong. The amount of disinformation is so overwhelming that we believe nothing until we can independently corroborate it. Therapists have the opposite kind of training. While you may not believe everything your patient says, it is good therapeutic practice to give the patient the encouragement that you do believe. And a good deal of what patients report has some basis in fact, although it may be highly exaggerated. In the area of mind control, people jumped in, believed everything they heard immediately, and paid no attention to the specialists who could have warned them that most of what people disseminate as brainwashing theories and ideas simply are not true. And unless programs, policies, techniques, government programs, and so forth have been corroborated as actually having occurred, there is no reason to believe them. So, for example, MKUltra was a program of the Central Intelligence Agency, which had 149 sub-projects on every avenue of mind and behavior control. We know that was a real project, and we know what the sub-projects under it are. But there are many names that have been circulated of other projects, and they cannot be verified. And if they cannot be verified, and you can't prove them, your belief in them will hurt you in a court of law and also in doing good therapy. And so be aware that you will be called into question about the literatures on mind control, brainwashing, and particularly police interrogation. Because the way police talk people into false confessions is the way these lawsuits are framed, that you've talked patients into false memories. And there is a direct correlation between the literature on police interrogation and the allegations against therapists in this area. All right, let's talk about informed consent. The notion of informed consent is relatively new in law. Although there were informed consent ideas earlier, it was the Nuremberg trials that finally generated the essential notion of informed consent. The law has always felt that an individual is autonomous and entitled to be the sole owner, possessor, and dealer of his or her mind and body. And anybody who seeks to tamper either with the mind or the body must get informed consent. Informed consent now should be used not only as a way of getting permission from patients, but also as a way of giving information to them. The risk disclosure cases that are mostly in the medical malpractice area have held doctors liable for failing to deliver information about risks that have only a 2% likelihood of occurring. And so the notion of informed consent is that the patient is entitled to know everything that he or she needs to know in order to make an informed choice. Now, in the informed consent area, the modern false memory argument or attack on therapist argument is that all of psychotherapy, at least on the analytical side, is experimental. And therefore, everything you're doing has not been validated by science. Part of what gives this argument its power is a 1993 decision by the United States Supreme Court called Daubert versus Merrill Dow Pharmaceuticals Incorporated. You may have heard about it. The facts of the case have no relevance to us at this point, but what the Supreme Court said was that if expert testimony is going to be admitted into court, there are 4 criteria that must be met. First, whether the theory or technique has been tested or can be tested. This is a principle of verifiability. Whether the theory or technique has been subjected to peer review and or publication. Whether the theory or technique has a known or potential error rate. And finally, whether the theory or technique is generally accepted within the relevant scientific community. It is my belief that you can meet all of those criteria, but in order to do so, it is necessary to do longitudinal studies on the effectiveness of various forms of psychotherapy. And it is necessary to show that the methods and techniques that you use are indeed curative and have low potential error rates. The more scientific studies you have on your side, the less vulnerable to legal action you will be. And therefore, what is needed at this time is for the profession itself to stand up and convert art into science and make sure that the kind of studies that the Supreme Court is going to insist on are available and delivered. And those studies then have to be disseminated across the profession itself. Now, while we're talking about the profession itself, it is my view, and I'm sad to say it, but I don't feel that it is inaccurate, that the major professional organizations have let you down, and their insurance carriers have let you down. In this moment of your greatest need, they have issued the greatest silence. If the literature shows that repressed memory in 37 studies is a concept that can be validated, where are the professional organizations making that point? Where are they in the court cases? It is necessary for, if the APAs and the AMAs are not going to speak, or even worse, are going to speak with a wishy-washy voice, then the public's going to only hear one side. This is like the story in law of the guy who was called to grand jury duty, and he didn't want to do it. The grand jury is a body of citizens that is convened to hear the prosecution's case. And if the prosecutor has enough evidence, the grand jury will indict. It's only the prosecutor's case that they hear, and only for the decision of whether there's enough evidence to indict. So this man went to the judge and said, I don't want to sit as a grand juror. And the judge said, why? The man said, well, I only can hear out of one ear. And the judge said, well, you're only going to hear one side of the case, so you're going to sit. Well, the public has only heard one side of the case. And for organizations such as your own that are most directly threatened, you should have a media campaign. All of you can go home and write letters to your local newspapers. You are vast in your numbers and in the regions that you serve. And writing a letter about the true science of these issues and countering the media barrage from the other side is essential in this day and age. And so not only is it necessary for organizations most directly threatened to take affirmative action in the outside world presenting your viewpoints, but you should work inside the bigger organizations to galvanize them to action and to stop their silence from being just one side of the story. Now, my time is short. There's always so much more to say, but I don't want to be pessimistic about this. In the short run, it seems to me, things look quite despairing. Headline after headline acts as Chinese water torture. One drop at a time wears a hole in your head. But in the long run, I have to think of this the way we think of the Soviet Union under Stalin, where what was politically correct was scientifically accurate. And the biology and the psychiatry in the Soviet Union for 30 to 40 years wound up being an adulation of Marxist political theory. And when that was finally thrown off, scientists could get back to the good work that they necessarily need to do. I think we're experiencing the same kind of thing in this area right now. And I want to close with a remark of Arthur Schopenhauer, which it seems to me fits the current occasion. Schopenhauer said, all truth passes through three stages. First, it is ridiculed. Second, it is violently opposed. And third, it is accepted as being self-evident. Now that we're in stage 2, can stage 3 be far behind? Thank you.
We've been listening to a presentation by Professor Alan Scheflin, Professor of Law at Santa Clara University in California, and this comes in the wake of the U.S. government attempting to bring criminal charges against psychotherapy and indeed, in effect, criminalizing psychotherapy. And this is one of the prime resources available for victims of sexual abuse, sadistic abuse, and mind control. And I can't help but asking, what is behind this? Why is the U.S. government trying to criminalize these resources? What is the motivation for their actions? Is it that they're worried that victims of U.S. government mind control and organized child pornography and prostitution are healing and talking about their experiences, exposing the U.S. government's role in these atrocities? I think it's a question worth asking. You've been listening to the International Connection on CKLN 88.1, and we're continuing with our radio series on mind control.